Yes, Mr. Smith. Are we going to be given more stuff?
Well, the pack's being made up as we speak.
Oh, right.
I think we have also found the additional document, the missing contract as well, and that's being done. One's very difficult to read because it's the reverse side, and we've got A3s coming as well. I think that simple, so it's legible.
Thank you, sir. Yes, Mr.
Lord, my Lord, I'm going to set out a structure. I want to start with two important points. The first point is that when one looks at the grounds of appeal in this case, they're very different to the way in which the appeal is now put. In my submission, what's now sought is essentially a rehearing of the trial or the summary judgment application before Mr. Justice Andrew Baker. And I say that's dangerous because there was a great deal of evidence before Mr. Justice Andrew Baker that isn't before this court. The second point is this, that the test of up to reasonableness is by its very nature a matter which is intensely fact sensitive. Indeed, we didn't go there, I don't intend to take you, but Lord Justice Coulson in Good Life says each case will turn on its own facts. The reference for that is paragraph 91 of Good Life. Now, I say that for this reason, that there is little between me, if anything, on the law between my learned friend and myself. I'm not going to take issue with almost any of it. I do have perhaps a difference of emphasis in relation to the chain of Court of Appeal cases that we saw from 2001 through to 2018. I don't put those cases anywhere like as highly as my learned friend would put them to you. But other than that, I don't take issue with his description of the law at all. In particular, the points made about Purnell, I agree with, and in my submission, so did Mr. Justice Andrew Baker. He found for the appellant in relation to Purnell. So on that basis, what I say is this, that there are some matters which became apparent this morning in relation to the underlying factual matters of this. This isn't a classic tripartite case. It's informative, but when one looks at how the contracts were formed, it's nothing like the classic hire purchase case. And that's why this case is different. The reason that Mr. Justice Andrew Baker found for the respondent in this case was because this is an unusual case, and it's an unusual case on its facts. And in my submission, as an opening submission, Mr. Justice Andrew Baker was right on the law, and nothing he said contradicted anything my learned friend said this morning. He then applied the unusual facts of this case to that law, and in the judgment made it clear that on many of the points that he raised, that the facts he'd relied upon were not really an issue, and then came to the only conclusion he could, which is that there was no real prospect of success for the appellant arguing that the clause 5 was unreasonable under UCTA. And that is why I say, when one looks at the permission application and the reason that Lord Justice Males gave permission, it's very different to the actual appeal. Lord Justice Males makes a point which I would say is a point on the test of summary judgment. It's whether or not the judge was able to make the decision without hearing evidence on certain facts. That's not the appeal that your Lordships are hearing this afternoon now. You're hearing a very different appeal. It's also not the appeal that's set out in the grounds of appeal. So perhaps if we could look first at the grounds of appeal. That's in the bundle, tab 2, page 16. I'll quickly go through them, but I've grouped them in 3 ways. One is what I call the Purnell grounds. Secondly, the contractual nexus with D2 ground. And then thirdly, what I've loosely called factual grounds, although they're not quite closely related. So ground 1 relates only to Purnell. And it says that the judge gave no proper consideration to the fact that the effect of the conclusion he reached left the appellant vulnerable to the trap referred to in Purnell. We haven't really heard submissions on that this morning. And the reality is we say that that's simply not correct. The trap in Purnell was the trap where Purnell was dealing with the earlier authority, which you referred to, R&B custom brokers. that you could be in a situation where, because you were dealing with a HP company rather than a supplier, that the law was different, that took away the rights you would have had against the supplier. And that was reversed, and I accept it was reversed by Purnell. It was followed in Danker. The judge found for the appellant on this point, so there is no trap. There was no trap here. The only trap that one could say was here was the point that Lord Justice Phillips made, which relates to the way in which the situation where the hire company could negotiate his own protection against the supplier, but the eventual user couldn't. Well, I'm going to come to that in due course in the facts. It's just not the case here. It's the other way around.
Forgive me, I thought the trap was very simply that somebody who contracts with the supplier will have rights against the supplier because they know the goods, are responsible for them, etc. And if you contract with the hire purchase company, if the hire purchase company is able to say, well, we have nothing to do with these goods, and so we can't be held liable, then you have fallen into a trap because you'd have been better off going directly than going to the hire purchase company. And what Purnell says is that can't be right. You must be in as good a position against the hire purchase company as you would against any other supplier of the goods to you.
I don't disagree with that point. I think my own reading of Purnell is that in Purnell, they were talking specifically about the submissions that were made in reliance on R&B custom brokers, which I think is slightly different. But I accept that trap exists. And to that extent...
But isn't ground one correct? Because the position, as I understand it, to dispute this, the position that the appellant is in, is let us assume for the moment, as I think we must on a summary judgment, that they have no claim against the second defendant. That must be the basis. No. I'm going to take some documents. In April of 2014, when this was being negotiated, the only negotiations were between the appellant and EvoBus. And they negotiated warranties. They negotiated extended warranties. And I will take the documents. I was planning to do that. Notwithstanding that it was then done through a hire purchase company.
Well, what happened was the hire purchase, that was done. I mean, earlier my learned friend made submissions, and I don't think there's no criticism because I think it was the way the questioning flowed that gave the impression that what happened was Dawson's went to EvoBus, bought these buses, they sat there waiting to be rented out, and then were supplied to LastBus. What happened was LastBus approached Evo. And I can tell I was going to take the pleadings, but Evo then, there's a series of representations by a man called Mr. Beagrie from EvoBus who tells LastBus how these buses are consistent with the old buses and that they meet their needs. There's then the agreement, which is pleaded in the appellant's own case. This isn't my case, this is their case. That I think it's the 14th of April 2014, they reach a point at which they're bound. And they then refer to terms and conditions.
Sorry, who are bound?
It's the appellant's case that they were bound to buy the buses from EvoBus as at the 14th of April 2014. Yes. At that point, the respondent wasn't even on the scene.
Yes.
And it's at that point, and I'll take you to the order forms, because in the order forms there are terms and conditions attached with warranties in them. Now, there are letters which aren't in these bundles, which demonstrate that Mr. Sullivan, from the appellant, was attempting to negotiate, or I think did negotiate, extended warranties, warranted over 48 months and so forth, which warranties that there was no negotiation of that nature between Dawson's and EvoBus, because the contracts had already been agreed. This is the important fact about this case. It's not classic tripartite. There was already an agreement between EvoBus and LastBus. That agreement went forward and was financed by Dawson's. It's not the classic case of simply somebody going into a car dealership and saying, I'd like that car.
That doesn't make any sense. Legally, it was financed by Dawson's.
But it does, because if in April a contract is reached pursuant to which EvoBus make certain promises to LastBus, that contract is valid.
Well, unless it's superseded by a different contract.
Because the contract itself provided for the use of hire purchase and actually provides.
None of this have we seen, and none of it's referred to in the judgment.
And that's the danger of this being treated as a retrial of the original summary judgment.
So it's not a retrial. The question is whether, on what we see in the judgment, the judge was right to give summary judgment.
Well, these matters were all before the judge at the summary judgment application.
Yeah, but they're not referred to in his judgment.
Well, what I can do is I'll take you in let me take you to the supplementary bundle.
Mr. Benzie, I don't follow this. If the points you've just made prove to be right, then maybe the claimant has a case for breach of contract against second defendants correctly. But as far as I can see, Evo will say, there's no contract with us. We're not the seller. We're to you. We're not the supplier. We sold to Dawson. They're out of the case because of summary judgment. So, sayonara, goodbye. You have no remedy against anyone.
Well, I have two responses to that. The first response is an important one that we don't need to look. I say one of the flaws in the appellant's argument is that they say to you that we can't deal with this until we go to trial because we need to know the outcome of the contractual dispute between the appellant and Evo. That's fundamental to the grounds. Well, it certainly is one of their grounds of appeal.
We don't need to know the outcome of the dispute. The proposition is simply that the claimant's case against your clients, the claimant's case against Evo, and your Part 20 claim, contribution claim, whatever it is, against Evo, should all be tried together.
Well, but in my submission, firstly, the first point on that is that it is one of the points of appeal that the judge couldn't deal with this before that case was decided. The case that's between Evo and last.
We do have Evo's defence.
We do.
Evo says very clearly that the purchase orders were superseded by subsequent contractual arrangements where they sold to Dawson and Dawson hire purchase to the appellants.
But fundamentally, my lord, you have to look at the situation as at the date of the contracts. My lord, you mentioned that the point about the compatibility between the contract between EvoBus and LastBus and the HP agreements. If you can go to page 89 of the bundle.
This is the supplemental bundle.
No, the main bundle. Now, if I can ask you to read paragraphs 23 through to 25.
Sorry, 24 is rather a mouthful. What's the gist of it?
Well, in essence, it's a term which provides, in my submission, for the it acknowledges the fact that HP or lease purchase may be used to purchase the buses, and what it does is it modifies the obligations of EvoBus so that they don't have to deliver to LastBus. It also goes on at the end, as you'll see, to say that there's no liability beyond the liability in this contract, so the contract between EvoBus and the appellant. Now, I raised that point because what we have to look at is not what a judge decides in 6 months or a year's time, not what people thought when they pleaded their case. We need to look at what people were thinking when they entered into the hire purchase agreements. And as at the date of the hire purchase agreements, objectively, there is no doubt in my submission that what Last Bus thought it had was contracts with EvoBus. And it was merely approaching Dawson's in order to obtain financing in accordance with the provision that I've just shown you in the...
Does the judge so find in his judgment?
I'm just... My Lord, if you go to paragraph 41 of the judgment. It's not directly on the point as to exactly what the contractual structure was, but in my submission it shows that the judge was alive to the fact that there was a contractual negotiation between...
Well, what paragraph is he referring to, do you know?
Well, paragraph 39. I'm sorry, I've...
Paragraph 41 you draw attention to. He says
Paragraph
at
41.
trial, Dawson might well succeed more simply on the logic of paragraph blank above.
Well, I'm not sure there is a reference to the contractual structure there. Well, what I can say is that this contractual structure, A, it's in the pleadings, and B, it was in the evidence that was before the judge at the hearing. So the judge was well aware that this wasn't a stage, this wasn't the classic where there's no contract between the supplier and the end user. It was a case where there was a contract between the supplier and the end user, certainly in the view of all the parties as at the date of the contract.
But the judge, at the date of this application, this hearing, the judge was second defendant's defence before the judge?
I can't recall that. Certainly the second defendant's... Last I have that checked.
Look at the date of it.
30 October 2022.
Yes, so it was, well, I think it was before the judge, but it was, his judgment was the 9th of November.
I can say it definitely was, because I just looked at the original
Yes.
bundle.
So the judge knew that EvoBus was saying there was no contract
Yes.
with Last Bus.
Yes, but respectfully, Lord, that's irrelevant. The test you need to apply isn't what EvoBus and Last Bus thought. As
You say it's what the parties thought at the time of the contract,
Exactly.
but the judge doesn't address this at all.
But
Does he any reference in the judgment to Last Bus believing it had a contract with EvoBus?
well, the reason I raise this, when it's put that this is a classic tripartite agreement, I'm going to come to the point that your Lordship said this morning that the problem with these sorts of arrangements is, and you said that, the end supplier is not in a position to negotiate protection from the end user, is not in a position to negotiate from the supplier, whereas the hire purchase company can negotiate. That's not the case here. That's on the evidence and on the pleading. That's not the case here.
That's with respect, that's a different point. That may go to reasonableness, but it doesn't. The EvoBus's defence says, rightly or wrongly, paragraph 49, on or about 15 July 2014, purchase orders were superseded. Claimant entered into HP agreements with Dawson. EvoBus separately entered into contracts with Dawson. I mean, the judge wasn't in a position to say, well, that's manifest nonsense.
That's correct. But what the judge could say was, by looking at the documents that existed at the time, and particularly in April of 2014, when Dawson's weren't even involved, there is clearly a contract, or certainly an intended contract. And it doesn't matter the extent to which that contract is legal, valid and binding. Doesn't matter. It's what objectively the parties thought at the date they entered into the HP agreements that is the question on relevant.
So do you say, have you put a respondent's notice in to say the judge should have taken those matters into account? Because he hasn't taken them into account.
My lord, no, we haven't.
So where do we go on it?
Well, what I say is, when you look at the question of whether, firstly, when you look at the points of appeal, it's all irrelevant anyway. It's got nothing to do with the points of appeal in my submission. But if it's simply on the trap point in Purnell, what I say is that it's not a point the judge has made a finding on, but it was a relevant matter that was before the judge. And when this court is deciding whether or not the judge erred in deciding that the clause was reasonable or unreasonable, you do have to consider all the evidence and the pleading that was before him.
Well, we look at his reasons, don't we?
And you do. But in my submission, you look at whether he's wrong in law. And the problem with this appeal as a whole is that it's an appeal that's put as an appeal on law. But in my submission, when you look at the law, nobody's pointed to me and said where the judge actually got something wrong on the basis of the law as it was put this morning. What we've got to is a dispute which is said on the facts. He got it wrong. And on the facts in my submission, he didn't get it wrong. He got it right. And he got it right applying the law in exactly the way my learned friend, Mr. Jones, explained the law this morning.
Well, we're very familiar in this court with the injunction that we shouldn't island hop on an appeal, but that's an appeal from a trial. And here this is a summary judgment.
Well, that's right. But what I say is that when you look at the facts as a whole, most of the matters that the judge, and I will come to them in due course, most of the matters that the judge relied upon in relation to the statutory guidelines for upturn were matters which he says expressly are either not an issue or demonstrably true. And in those contexts, well, he doesn't make an express finding as to the whether or not there was a contract between EvoBus and LastBus. That's because he didn't need to. He was considering the situation as it was at the date of the contract. And on that basis, part of that must have been the entire factual matrix. Factual matrix includes the points that we've just discussed. And for those reasons, I say that the trap in Purnell doesn't apply here, because this isn't a case where there was no agreement between the supplier and the end purchaser.
The supplier says there wasn't. Or that there was in April, but in July 2014 that was superseded.
Well, my lord, if one looks, I've taken it to the pleading. What is the basis for that? But again, that's what the supplier said when it pleaded its defence. At some point future, I can't remember the date of the defence. Objectively, at the time, I don't know what EvoBus would have said, but objectively at the time, the parties to the contracts we're talking about today, LastBus and Dawson's, would have looked at this document that's in the bundle, seen the contractual warranties that protect LastBus and not Dawson's, and would have concluded that Dawson's has ample protection.
Well, I just don't know where you get that from. That's not a finding the judge has made.
But what I'm saying is the factual matrix. I can't say it's.
But where does that fact come from? You can't. Can you point to evidence in that regard? Or
Well,
it's not in the judgment, and I haven't seen
supplementary bundle, page 155. this is an order form. It's not signed, but it's dated 14th of April 2014. You see that at the bottom of the page. If you go down to the next page, 156. At the bottom of the left-hand column in 156, you'll see the heading warranty. And that goes over to the next column.
Where does this get us? Because this is an unsigned order form, and the terms and conditions say a contract of sale shall only be made when the seller acknowledges in writing, signed by a director, the purchaser's order. So
Well,
where's that?
Well, I say where it takes you. It's Last Bus's pleaded case that this was a contract. It's Last Bus's pleaded case that as of the 14th of April 2014, they were obliged to buy these buses. They're all matters that the judge was entitled to take consideration of. And what I say is that given that's their pleaded case and it's in their pleading signed with a statement of truth, that must reflect their objective understanding as at the date of the agreement.
Well, they were saying this is the case. Do they say it's their understanding?
Well, again, we don't need to look at the date of the agreement to find a concluded contract. We need to say what was the understanding.
So where is the understanding?
Well, there is no finding in the judgment on this. But what I say is when you look at the documents, it's hard to say. It's hard to say how a learned friend can stand up and say that as of in July 2014, when the first HP agreement was signed, that they didn't understand that they already had a contract with EvoBus because they negotiated warranties. They had warranties for these buses.
I really don't understand. So EvoBus says there is no such warranty. The appellants now, their lawyers say we've got a claim against Dawson because your clause is unreasonable. And we've got a claim against EvoBus because there was a contract.
Yes.
Nobody's pleading what anyone's understanding was at the time. This is a legal assertion in a pleading. Where do we find an assertion or evidence that there was any understanding at the time?
Well, I can't. There is no pleading. What I say is this: that the judge had to look at the evidence before him. The pleadings were before him. The evidence of Mr. Sainthouse and Mr. O'Sullivan were before him. When you look at that evidence in the round, I say it's impossible not to conclude that as at the date of the contract, the first contract in July 2014, that the objective understanding of both parties wasn't that they had an agreement with, there was an agreement between Last Bus and Evo. They negotiated over a long period of time. They received representations which they relied on at the time.
Did Evo have that understanding?
No, I'm saying Last Bus had that.
But did Evo?
Well, again, we have no evidence what Evo did.
We've got no evidence as to what Last Bus did.
This is the point. We had no involvement with Evo. The involvement with Evo happened much earlier, and it only existed between.
Sorry, I wouldn't claim to be an expert on hire purchase, but you've shown us unsigned contract, but never mind unsigned, April 2014. At that stage, your clients aren't on the scene at all.
No.
And had matters stopped there and the claimants paid Evo direct, perhaps with a bank loan, who knows, you wouldn't be here and there would be a straightforward dispute. The claimants say to Evo, you supplied buses which are rubbish, and Evo say we've got exclusion clauses, and there would be a question of reasonableness. But Evo say, and I understood this is the mechanism of hire purchase contracts, that is superseded by two contracts back to back in July 2014, claimants with you, you with Evo.
Well, there's two issues here. One is Lord Justice Phillips is making the point about where that's pleaded, and I think the Lordship's point is more of a factual point on to what.
Well, it's pleaded in Evo's defence, paragraph 40.
And what you, I mean, the point on your factual point is to say that things moved on, and had they funded with cash, the contract would have kept going. Had they not, then something else happened. It is contradicted by the point I've already taken you to, that the contract they entered into, LastBus entered into with EvoBus, specifically provided for the use of hire purchase finances, and specifically provided that in the event that they used hire purchase, the contract between EvoBus and LastBus would continue in force.
Well, that's as maybe, but perhaps that's what would be found at a trial. But doesn't seem at all obvious to me. Evo are saying they're giving notice by paragraph 40 of their amended defence. If this goes to a trial, claimant against us, we will say this has got nothing to do with us. You've got no cause of action against us because the contract which you once had with us, or were thinking of having, was superseded in July 2014, and after July 2014, any provisions in the previous contract are no longer binding. That may be right, it may be wrong. It doesn't seem to me obviously wrong, and the judge hasn't found it's obviously wrong.
Well, the furthest I can take this is to say just this, which is that when the court looks at the decision the judge actually made in terms of reasonableness, it must be the case that he took into account the factual matrix. And in my submission, the factual matrix included the matters I've taken you to, the existence of the contract in April 14, the provisions of that contract that allowed for the use of hire purchase, the negotiation of warranties, and as I say, the evidence before the judge on warranties was more extensive than you have. And then when the judge comes to look at what was the objective understanding of the parties in consideration of reasonableness in July and afterwards 2014, those are all factors which he legitimately could have taken into consideration. Now, I accept that's not expressed in the judgment, but when one looks, and this goes to the Purnell point, because the strongest way Purnell can be put against me is Lord Justice Phillips has made more than once, is that why would anybody agree to enter into a contract with a hire purchase agreement where they exclude all liability if they've got no comeback against the actual supplier? So the answer in this case is, and this does align itself with the subsequent authorities we'll talk about commercial relationships. But in this situation, when one's looking at the proper allocation of commercial risk, in a situation where the parties all understand that what's happened is Mercedes have provided, EvoBus are Mercedes, now called Daimler Coaches, they're providing warranties to say that these coaches will do certain things, and the warranties maybe not as extensive as Section 14 or Section 10 of SOGA, but they are providing that comfort. That's the level of comfort that LastBus have sought and obtained. In those circumstances, the question of reasonableness is very different to the classic tripartite situation where somebody has bought a car in a dealership. So in my submission, those factors are relevant. And the 2 points where I say the points of appeal have strayed away from that is, one is they don't give any consideration of the fact that what matters is what the parties believed as at the date of the agreement. And the way the facts have been put so far don't give any consideration to the extent of the negotiations and the extent of the protection sought by LastBus when they were negotiating in April 2014 for the contract I showed you.
If we're looking at what the parties understood at the date of the contract, both parties, don't we need to see your agreement with EvoBus?
Well, again, no, because LastBus couldn't have seen them, and so the test is objective. So the question is, so the documents that weren't known between the two parties wouldn't be relevant. And there's no.
So you saw the documents passing between Claimant and EvoBus, did you?
I don't know. I'd have to turn and
well, if you didn't, then on your analysis, none of them are relevant.
But what you had was you had the discussions, because the whole course of this wasn't the course of we're coming to you, Dawson's, because we want to buy these coaches. Can you sell them to HP terms? The whole course of discussion and then again this comes from the evidence that's before the judge, was that we've arranged to buy these buses from EvoBus. Can you, Dawsons, provide the money?
I mean, the more you say, Mr. Bentley, the more my instinct would have been, as a first instance judge, that the whole of this, Last Bus, Dawson's and EvoBus, ought to be looked at together at a trial, certainly looked at together on maybe a preliminary issue. And if that wasn't the case because there was otherwise, I would say there was some other reason, in that plainly these matters are closely intertwined.
But two responses to that, Lord. The first one is that that's not the appeal we're hearing. I mean, that's an appeal, and I have to say that when one looks at the permission in this, the permission that Lord Justice Males gave sounds a lot like the way you've just expressed it yourself, Lord. But the appellant doesn't appeal on the basis that the judge got the test for summary judgment wrong. They appeal on the basis that he got the test for ACTA wrong. So the second point is simply this, that when we look at the judgment, we look at the facts the judge decided on, they were largely matters that weren't an issue. And that's why he found, on the basis of the summary judgment test, that there was no real prospect of success. Lord, I'll move on. I'm going to address this in...
Well, he does. Sorry. The grounds of appeal do include ground 4. The judge concluded wrongly it was appropriate and proper to determine the reasonableness of ours exclusion in isolation and without any determination of whether there is a contract between A and D, and if not, why not? Or if there was a contract, whether it contained, etc., etc. So that seems to me is a direct attack on the judge's approach to granting summary judgment in these circumstances.
Well, what I say to that is, what that ground of appeal is saying is that the judge needed to decide, or a judge needed to decide at some point, whether or not there was a contractual relationship between A and D2. For the reasons I've said, I say that's simply wrong. I mean, there is no, what a judge decides at trial is not something that would have been in the minds of the parties at the date of the original contracts. I also say that one would imagine that if it was being asserted in that point of appeal that it was because the judge had erred on the test summary judgment, that they would have said that. In my submission, what's being said there is, and it's a constant theme because it's my second grouping of the points of appeal, is that the judge couldn't make this finding without making a finding on the contractual relationship between the appellant and D2. And for the reasons I've already said, that's just not right.
We haven't yet seen, I can't say I'm eagerly awaiting, but we haven't yet seen the Part 20 pleadings. But presumably, your Part 20 pleading against EvoBus says, in no doubt more sophisticated language, this is all your fault, and if we are liable to the claimants, which we don't accept, then you've got to pick up the tab because it's your defective buses, and either the trial judge finds, query surprisingly, that it's perfectly all right for EvoBus to exclude their liability, in which case the claim fails against you, you don't have any liability, and the claimant has to pay all the costs, or the trial judge finds that EvoBus have to carry the can, in which case they carry your can as well. What's wrong with that?
Well, but I think the answer to that is there's no reason in these circumstances. So if the parties have agreed to a certain contractual format and have agreed to certain limitations, the parties should be kept in litigation for a long period of time at great expense. I mean, on that point, just so I'm absolutely clear, because I looked quickly at lunch break at the Part 20 pleadings. Just so you're clear, I don't think this goes to your question, but I want you to know it. It is that we plead that our standard terms are applied, which would give us protection against EvoBus. EvoBus plead back that their standard terms applied, unsurprisingly, which include an exclusion clause.
Yes.
But I mean, clearly that the way your lordship states that we all go to trial and we we have that decided there, is a way of dealing with this. In my submission, if the UCTA reasonableness test can be dealt with on a summary basis, there's no reason why it shouldn't be dealt with in that way. And what the judge found in this case is that on the basis of, say, largely things which were obviously true or uncontested, that he was able to make that decision, then that should be the best way to do it, because it saves exposing a party to the time and expense of litigation when they don't need to be. I'm mindful of the time. What I'm going to do is I'm going to structure my submissions loosely around 4 points. One is the nature of how you address UCTA appeals. Two is context. Now, we've dealt with quite a lot of that, so it probably won't take me very long.
Yes.
4 points of law which I'm going to make, which I think have largely been made by my learned friends, and I don't disagree with them. And then finally, some submissions on each of the grounds of appeal, which I think, given where we are, I think I need to make them, but again, they'll be brief.
Yes.
On the approach to the appeal, we say that this is a decision of an experienced commercial court judge, and the Court of Appeal shouldn't interfere with that decision, save in exceptional circumstances. Now, my learned friend referred you to some authorities. I won't take you there because I think you were taken to it. It's cited in most of the authorities, actually, but in Granville,
none of these are summary judgment cases, are they?
They're not, no. But
these are saying you shouldn't interfere with the judge's decision on reasonableness after a trial.
After a trial, many of the, or certainly I think 3 of these cases at least, are preliminary issue cases.
But preliminary issue is a trial.
Well, they are the trial preliminary issue, that's correct. But it's the citation from George Mitchell and Phillips, which is repeatedly cited, which says that the Court of Appeal should treat the original decision with utmost respect and refrain from interference with it unless satisfied that it proceeded on some erroneous principle was plainly and obviously wrong. Now, I accept the point, and I was going to address the point, that none of these cases are summary judgment cases.
Is there any case that you found where the question of reasonableness of a contract term has been determined on a summary basis?
No. I've looked and I can't find any. It's also the case that in Mitchell and Phillips, it was said that this is the sort of area, and I say that it's a matter of stating the obvious, where there can be a legitimate difference of judicial opinion. It's quite possible that one judge looking at this clause could make a different decision to another judge. Now, I fully accept that there is a difference between saying a decision of a judge after even a preliminary issue trial and a decision of a judge at a summary judgment hearing. But even in those circumstances, the judge had the benefit of what was quite extensive witness statement evidence with all of the documents attached to it. He will have read all of that. He had a day's worth of submissions from myself and my learned friend.
Presumably there wasn't disclosure.
There wasn't disclosure, no.
Or expert evidence.
No expert evidence, no. The only expert evidence which has figured in this case to date, it relates to the fitness of the buses. And I think you heard some of that from a learned friend.
So, for example, there might be expert evidence as to the availability of insurance for the various parties.
Again, I wouldn't push the insurance point on behalf of the respondent very hard, because there's an obligation in the HP agreements, which you always see, to insure the property itself. And that's the understandable point, that if an HP company rents...
That's a different point.
It is a different point, but whether or not you could have insured for what we call classic product liability type defects, that's never been pleaded, and it doesn't figure in this case. I don't say that either party or any of the parties ever intended that there would be insurance in relation to those sorts of matters that are complained of now, in fact.
But do you agree that the question of whether or not you were able to you were able to protect yourself against claims by Last Bus by your terms and conditions vis-a-vis EvoBus is an equivalent issue?
Lord, I accept that could be a relevant issue. issue. It was never pleaded, and it was never advanced as an issue that deals with this. I'd have to turn, but I'm fairly certain in saying that it's not usual for Dawson's to insure that type of liability, which is why it's probably never arisen. What I do say on this point is that this does turn on the sensible allocation of commercial risk. And I say that is a point you should consider, because if in this situation where you have high value contracts of this nature being negotiated between manufacturers and bus companies, if this clause is reasonable, what it would do, it would make Dawson's and other companies of a similar nature into the insurer of last resort for the whole industry. And that's another. I did, I think, make submissions on that basis to the judge. This is how the industry works. One of the points my learned friend raises, and I don't challenge, is that it would have been, as far as we're aware, impossible to get HP terms from any other provider of hire purchase in the market without exclusion clauses of a material similar nature.
Well, I see that, but why is that a point in your favour?
At the time, it clearly goes both ways. It's clearly a point the learned friend raises to show that there were no alternatives. But I'll come back because there was an alternative, at least. The point is in our favour is simply to show that if the whole market is using it, and the evidence is the evidence we had that the whole market was using it, or at least a very large part of it. Again, it's another indication when one's balancing up the question of reasonableness versus unreasonableness, that something is reasonable. It's a massive market.
It seems to me it makes it extremely important, if you're right. It's an extremely important issue as to whether or not these clauses are, in general terms, reasonable.
Well, without doubt. But what I'd say on that point, my lord, is this: that the evidence that was before the judge was that the motivation that Last Bus had for coming to Dawson's was because our pricing was the best. And the judge expresses it in the judgment that on the basis of APR. Now, I'm cognizant of what my lord said this morning about the extent to which standard terms, and there's no dispute they are standard terms, are negotiated. And of course, the terms themselves weren't negotiated. But Mr. O'Sullivan of Last Bus came to Dawson's because he wanted the pricing. Now, that pricing will obviously be based on a number of factors. One of those factors is liability. And so the reason, or one of the reasons anyway, that Dawson's would have been the best pricing in the market would have been because they don't have to provide for the risk of becoming liable for defects in the buses that they...
But you're saying that's industry standard, so...
I'm sorry?
I thought you said it was industry standard.
But that's why I'm taking up the point where my lord says it's so important, because it is so important, because the whole industry does not see itself as the insurer of last resort of the buses. And buses, by the definition, are all manufactured by large manufacturers. Yeah. And that's why now, across the board in hire purchase agreements, in my experience, similar sort of provisions apply. And one can question that in consumer cases and cases where you're dealing like Danko with photocopiers. But in cases like this, when you're dealing with large commercial organisations who are able to protect themselves, where we're looking at the balance between the cost of the finance they're seeking and the risks that they're willing to take. In my submission, that's one of the issues where the court should be very, very loath to actually get involved, because there are so many working parts in there as to how the risk involved filters through to the cost of the finance.
But if you're right here, and EvoBus is right that they have no contract, we're left in the position where Last Bus has paid 7.5 million for buses and had absolutely no recourse against anybody if those buses were totally useless. And that, as in Lord, I think Lord Mr. Justice Longmore, as he then said, had a particularly strong words about that sort of outcome. And that's what Pennell is all about.
Yes.
It's saying it cannot be right that somebody buys goods, hire purchases them.
Well, Justice Longmore said it offends reason.
Reason. That Last Bus is left with no remedy against anybody in these circumstances. And that is the situation which you say could well occur here if EvoBus is successful in their defence.
Well, I say that is a situation which could happen in this case. Now, one of the problems in this case is that you have rival exclusion clauses. Now, clearly, the question of whether EvoBus's exclusion clause is completely separate to the Dawson's clause, and the factors involved are very different because they are the manufacturer. And they've also, they've made, and it goes back to there was a discussion about the ratio of Purnell. Now, I think the submission I made to Mr. Justice Andrew Baker was that what Purnell said was that you can't normally, it's very hard to exclude liability for express representations made by your own agent. Now, I think that would be the situation you get to with LastBus. So in my submission, with Evo, in my submission, the likelihood is that any attempt by EvoBus to exclude liabilities for those sorts of representations.
That's if it's a contract at all.
Well, quite. But again, I say when one looks at it, the prospect of there being a contract is very high. I mean,
we can't proceed on a summary basis. Neither could the judge.
But again, I think here we conflate the test with overall questions of policy. The question here, the question of this appeal is: did the judge apply the test correctly? Now, the point that Milord makes is whether or not it's right to have these clauses in these types of contracts. And on the basis it's my submission, they are always in this type of contract, or certainly nearly always.
No, the question is whether or not they're reasonable.
Yes. Well, again, I say, I go back to the point that these cases are always fact specific. And on the facts of this case, I say the judge got it right. So the facts of this case, they are reasonable.
Sorry, I appreciate we're giving you quite a hard time, and I should let you.
Well, I'd like to develop that slightly further. Yeah. I think what I'd like to say is this: that this point that LastBus may be left in a situation where it falls between the stools and it ends up with no remedy against anybody. It's not a particularly attractive point, but it's the reality. They are a large commercial player. They bought 200 vehicles through Dawson's, 45 contracts, 20 years. If that's what they signed up to, the approach of contract law is that's what they signed up to. We don't undo bad transactions.
It does seem to me very odd. I mean, you referred to policy, and there's a high element of policy in the regime of UPTA. It's very odd that if they had bought a fleet of buses, possibly over a period, from Evo/Mercedes, direct, with no doubt bank loans and so on, they would have a potential remedy against a supplier subject to the supplier's exclusion clauses, test of reasonableness. But if, and will you bear with me for a moment and assume that Evo established that there is no direct contract, that as per the second defendant's defence, there's one contract with you, and then you have a contract with Evo, the claimants end up with nothing, irrespective of whether Evo Mercedes' exclusion is reasonable or not. Just never get to it. Now that's very odd. Why should there be such an entirely different regime depending on whether they buy on hire purchase or direct from the supplier?
Well, again, I'd say there's two issues. One's the bigger issue, which is when we're talking about the fact that these do appear to be ubiquitous. And if they are ubiquitous, that's a situation which appears to exist in the market. On the facts of this case, what I say is this: that if on the assumption that there is no agreement found with Evo, that they're left in that situation, that is because that's what they've signed up to. They agreed to we say on the face of it, they thought that they were agreeing a particular deal with Evo. And that's the only way to explain why they were negotiating warranties. If they've signed up to that deal, and either that deal isn't a contract or it's a contract and the loss is excluded, and then they've signed up to a contract with Dawson's and that loss is excluded, that is what they've signed up to. And the question for whether or not that's reasonable in relation only to the Dawson's term is simply whether, what were the facts that the parties objectively understood as at the date of the agreement. And I keep hammering that point, but that I say is crucial in this case.
All right. Well, as my lord said, and make criticism of myself. We've been giving you a hard time, so why don't you see if you can make some more progress, and we'll
I'm grateful.
try and hold our tongues for a couple of minutes anyway.
I was going to set out a couple of matters of context. Now, I'm going to do it briefly because we've had a lot of discussion about context.
Yes.
In fact, the friend's skeleton argument says context important, and we agree. The two main points of context. Firstly, and it's a point that was raised this morning, these contracts follow 45 previous agreements, 200 vehicles over a period of 20 years, all signed by the same person, Mr. O'Sullivan. Never has it been suggested that this contract is unreasonable, or sorry, the term in the contract, clause 5, is unreasonable. Now, I'm going to go back because I heard the discussion this morning, obviously, and what was put was, well, if the first contract has an unreasonable clause in it, we haven't entered into it because it's void, therefore there's no contract. So entering into 45 void contracts makes no difference. That was the discussion this morning. I say that can't be right because each one of those contracts will be different on a factual basis. The negotiation of pricing will be different. The factual scenario of how they did it, the relationship with the suppliers will be different. The warranty situation on the vehicles will be different. So we can't just stand back and assume.
Brother, your argument is it's all the same, which is why they can't complain. It's the same over and over again.
Well, I'm not saying it's something which is conclusive. But I'm saying it's definitely an important factor. If a party, and I think the judge felt it was an important factor, that if somebody agrees repeatedly to the same contractual term over a period of 20 years, that it's at very least it's an indication that there's no objection to it on the terms of reasonableness. Why would a reasonable and relatively experienced, relatively senior business person, who is very, very experienced,
UCTA actually is addressed to the ability of a party to rely on a contract term, and that's the point at which you have to consider reasonableness, isn't it? And so until you've actually sought to rely upon that clause, the question of its reasonableness isn't considered by anybody, certainly not by Last Bus. I mean, the evidence is, I think, from the relevant person at Last Bus that he never gave any thought at all to these clauses. And secondly, in any event, the issue of reasonableness was never raised, was it?
Well, there were 2 points. First, it's right that the test would only come if somebody challenged it. But where the terms of the contract are in every agreement that's been signed, I'll turn to the evidence of what actually happened in a second, but in a normal situation, one would expect that when a commercial person reads a term, a particular term which says we have no liability to you and you have no claim against us, if they objected to that over a period of 20 years, you would have expected them to raise an issue with it.
Well, I say every weekend I go into a fitness facility, and every time they ask me to sign the form, and I sign it, I don't read it. And then after I've been going there for several years, I have some sort of injury or some sort of accident, and they turn around and say, well, actually, you signed this, and it's got an exclusion clause. You must have thought that was reasonable because you've signed it 295 times in the last 5 years. That's not the way it works. It's only when the claim arises and the clause is relied upon that anybody has to think about whether the clause is reasonable.
With respect, I don't accept that as a fair analogy. If every time you went to the gym you were spending £9 million, I think that would be an analogy. But where Mr. Sullivan is signing these contracts in respect of millions of pounds worth of buses, which are the basis of his whole business, I think in those circumstances one would normally assume that in reality somebody would read or get a lawyer to read.
And if he had thought about them, he might each and every time have thought, well, this can't be reasonable because it purports to exclude my any remedy. And so if ever it comes to it, this will be unreasonable.
Well,
I'm not sure where this point takes us at the end of the day, because at the end of the day, you have to look at whether or not reliance on it is reasonable, and that only arises as and when it's relied upon. And the fact that somebody may at some point have noticed the clause, which there's evidence here, doesn't affect whether or not the clause was viewed as reasonable.
Well, as I say to you, the question of whether somebody noticed it, in my submission, objectively, somebody should have noticed it. The judge used the phrase that the fact that Mr. Sullivan never read any of the contracts, which was evidence, didn't change the objective reality. From the point of view of Dawson's, any reasonable business person would have assumed that the party that they were selling, they were hiring buses to, would have read the contracts and possibly got legal advice.
Sullivan may have had Purnell in mind.
Sorry, I didn't catch
He may have had Purnell in mind.
Well, I think we're looking at the objective reality. I think whether or not they had Purnell in mind, if he'd had Purnell in mind, he'd have probably had some knowledge of what clauses are unreasonable, and one would have expected him to say to Dawson's, "I'm not saying this is unreasonable." The second point, and it's a point that's just been raised, is that it can't be right to say that the answer to these clauses is that Mr. Sullivan chose not to read any of them.
Sorry, what did you say?
Mr. O'Sullivan chose not to read any of them.
Oh, I see. Right.
45 contracts over 20 years. Now, I say the judge got that absolutely right. The position is that the question is objective. And objectively, it's astonishing that some businessmen didn't read any of these contracts. Now, I hear what the Lord says, but I say it does go to the question, not conclusively in either direction, but it goes as one of the factors that go into the scales in deciding whether or not a term is reasonable, is the extent to which it's been accepted repeatedly over a large number of years in a large number of very valuable contracts. The third point was really about the contractual relationship between EvoBus and Last Bus, and I've already made that.
Yes.
I don't want to go there again. The legal submissions, I don't disagree with anything that any friend has said. The submissions I was going to make, one is the point that I've made ad nauseum about when you judge reasonableness, and it's at the date of the contract, and that's in section 11.1 of UPTA. And it's said in a number of the authorities, so I don't think you need my help with that.
Sorry, what's your submission on that? Just remind me.
You have to judge reasonableness
Yes.
as at the date of the agreement.
Well, is that right? My lord has been putting to you that you judge it when you seek to rely on it.
Well, no, it's a matter of law. I mean, I think that was a different conversation, my Lord. I think we were discussing when, if Mr. O'Sullivan was looking at the contracts, he would decide it was unlawful. Sorry, it was unreasonable. In terms of the test the judge has to apply, it's quite clear in the statute. So, section 11.1 of UPTA makes it clear it's at the date of the contract. And as you've raised that, it's in Watford Electronics and Sanderson. The reference for that is paragraph 49. If your Lordship sees, paragraph 49 starts at the bottom of the page. It's the penultimate sentence.
I think the point is that the distinction is that a party cannot, by reference to a contract term, exclude liability. So the issue arises when you're seeking to exclude liability.
I accept.
But the test is that the term shall have been fair and reasonable and to have been included
At the date.
at the date. So
I agree.
that's the distinction.
I agree.
Are you going to say anything else on legal submissions?
Lord, not very much. I'm going to address two other points and then talk about the development of the approach to commercial agreements in the particularly the three agreements, the three Court of Appeal authorities, 2001, 2003, and 2018.
Right.
The second point was the point made in relation to Purnell. I'm not going to do that again because we've had the discussion about Purnell. You've heard what I have to say. I think Purnell's ratio is limited to whether or not you can exclude liability for express representations. The judge was against me on that, so I accept that. So what the judge found was that it went further than that, and that he expressly found that you shouldn't have a situation where a party's remedies are dependent on whether or not they contract with a supplier or an HP company. So the judge was correct on that.
I thought in Purnell the term was implied.
So it was a representation made by an agent that the photocopier was suitable for the purposes that it was supplied. I think that's right.
Well, it was regarded as it was referred to as the disputed term, and the judge held the court held that the disputed term was an implied term of the contract. If you look at the top of
Yes, so I'm confused.
343.
The point was that in that case, the buyer thought it was dealing directly with the manufacturer.
It doesn't really matter how it came about, does
Yes.
it? What matters is the court determined that term which was in dispute was did form part of the contract. And what he says at what the Vice Chancellor said at 345 is that the disputed term may be implied rather than expressed.
Yes.
So it seems like he thought it was an implied term.
Yes. I'm not sure. I think my view on it was that the implied term arose from things that were said by the salesman. The salesman wasn't an employee of Captain, he turned out to be an agent of Captain. The third point, and it's probably the only point that really separates us, is the question of what you take from the three cases that I relied upon in the Court of Appeal, the Watford case, the Granville Oils case, and the Good Life case. I don't tend to take you through them. My own friend took you through all the references that I would have taken you to. And what I say is this: my own friend takes those cases and sets them up as a situation where essentially you have a different regime for certain types of commercial contracts. And he talked about reversal of the burden of proof. I don't say that for a second. I don't think there's any reversal of the burden of proof. I think what those cases show is that, firstly, it's recognised by everybody, and it's never been part of the respondent's case, that the legislation does apply equally to consumer and commercial cases, and I accept that. But what it also shows is that the Court of Appeal have said, in my submission for obvious reasons, that you do take a different approach to contracts agreed between commercial people, and particularly commercial people, in fact, commercial people who are of relatively same negotiating power. And I say that's a statement of the obvious, because when one looks at the various cases, so if you go back to like R&B Customs Broker, where you had a car being sold, and you compare that to a case like this, where you've got somebody buying £7 million odds worth of buses, it's not surprising that the degree of protection that that Parliament would have sought to provide might well be thought to be greater for consumers who are more vulnerable, and that's reflected in the authorities and passages my friend took you to, than the protection that's needed of businessmen engaging in high-value contracts. Now, all I say with that is it's another factor that one weighs when considering whether or not something is reasonable. It goes no further than that. In my submission, it's right to say that there is a trend. It's right to say that this court has repeatedly held that there is a difference of approach when dealing with senior commercial parties.
I'm not really sure myself what you mean by difference of approach.
Well,
You accept the test is not different, do you?
But the test is exactly the same.
You say greater weight.
Greater weight. I mean, the way it's expressed in the authorities, and even if you go back to even pre the legislation, going back to photo production, is this reluctance of the courts to interfere with arrangements agreed between commercial people who are taken to understand what they're doing and taken
Well,
to...
that may be the reluctance of the courts, but with all due respect, in this context, Parliament has spoken. And isn't our first duty as judges to apply the will of Parliament?
Well, that's of course correct, Lord. But the situation I say is simply this: that the courts construe legislation.
Yes.
In my submission, the statement that you were taken to, where it said that the purpose of UCTA is to protect consumers from draconian contract clauses.
Yeah, well, I'm not sure, speaking of myself, I would necessarily accept that is the only purpose.
I don't think that was what was said. I don't think it is the only purpose. I think it clearly has a broader purpose, or Parliament could have restricted it to consumers.
Yes.
In the same way that other legislation is restricted to consumers.
Right.
But what I say is this: it's perfectly accepting that the duty of a judge is to apply the intention of Parliament as requested.
Mm.
Well, we have unfair terms in consumer contracts regulations, which specifically had, whereas the clue is in the title here. This is unfair contract.
Yes, yes. Well, of course, when UCTA came in, we didn't have the regulations, and that's why, so for example, Section 6 has now changed, and so I think Section 3. But I think all I go as far as to say it's perfectly normal for the Court of Appeal in particular to take a view on legislation and to give guidance as to how Parliament would have considered.
All of that, with respect, I understand. Can I ask you about how the judge applied that line of authority at page 79 of the core bundle? Really, this is the judge's reasoning on why he allowed this application for summary judgment, your application for summary judgment, is essentially in 4 paragraphs, at paragraphs 37 to 40. Do you have that?
I do not.
Yeah, well, essentially what he does is that he summarises your primary argument, as he describes it, at paragraph 37, which has 3 component parts. He distinguishes Purnell at 38. And he says at 39, these factors are sufficient, still summarising your argument, to overwhelm the one factor that goes in the other direction, which is that LastPass didn't have the option to contract with anyone else on any other terms. And at 40, he concludes, you're right. There is no real prospect of LastPass resisting your primary argument. It's compelling and sufficient. There is no need for a trial. And the question I particularly wanted to ask you, if I may, is the way in which the judge expresses, well, what looks like a test to me, but correct me if I've misunderstood. At 37 little 1, he poses himself the question whether clause 5b is so unreasonable that it might have occurred to Dawson that in signing up to it, LastPass must not have properly understood it or considered it. And what's the judge doing there? Is he posing to himself a legal test?
Well, in my submission, what he's doing there, he's taking the point that we discussed recently about the number of times that LastPass had seen the clause.
No, that's number 3. I'm looking at number 1. The formulation at the end of little Roman 1.
Yes.
So unreasonable that it might have occurred to Dawson that in signing up to it, LastPass must have not properly understood it. I know where he got that from, because we've been shown it in the case law.
Yes.
And that, on the face of it, that appears to be posing a legal test. But you may say that I'm wrong, and that's why I'm putting this to you, so you can make your submission about it.
Well, given where it comes from, I would submit he's not imposing a legal test. He's simply raising that as one of the 3 factors that he raises as the primary reasons why he has made the conclusion that he goes on to make later in the judgment. It's one of those factors, and it goes back to the point I made, which is that the whole UCTA test is a matter of considering all of the factors and weighing them to decide whether or not a clause comes out as reasonable or unreasonable. In my submission, it is, in my submission, reasonable, because again, I do think that goes to the point that when the problem he had was that on an objective basis that I had made submissions to him about the fact that this clause had appeared in all of the previous agreements. The problem he had to deal with was that the evidence against that was that they had never been read. I think there he's trying to deal with that point in saying that from the point of view of Dawson's, The fact that they'd included this term in all of those 45 agreements, that at no point anybody had ever raised any objection to it, is a factor that he took into consideration.
But that's 3, isn't it? He dealt with that at 37.3. This must be something different.
In my submission, it's an overlap. I think what you're looking at, what one is going to is the fact that there were alternatives. And the alternative he found clearly was the ability to seek finance from a bank. Now, I think what he's saying there is that if if Last Bus had considered that the clause was so unreasonable, they could have gone elsewhere, or they would have expressed their dissatisfaction with the clause to Dawson.
If they'd gone somewhere else, apparently we're told everyone else has the same standard term anyway.
Well, his decision was that on the basis of pleading, and you were taken to pleading this morning, that they could have sought bank finance.
Sorry,
they could have sought bank finance.
I see.
So if they'd gone and taken a loan from their usual bankers, they could have gone direct to Evo and bought them with, again, quite possibly with an exclusion clause on the basis of
that reasoning rather falls foul of Purnell, doesn't it? The argument, well, you could just as well have gone and you could have bought these directly. The answer to that is in Purnell is, well, it shouldn't be any different. You shouldn't find yourself without a remedy because it's a hire purchase contract.
Well, again, I think the point he's making there is that there is a specific line. The authorities talk about the availability of alternatives. So I think that he's looking at there is an alternative. Now, whether or not that alternative would have given them and again, he considers this as well, whether or not that alternative would have given them a remedy against the EvoBus.
That just really goes as to bargaining strength, doesn't it?
Yes. And again, his conclusion on bargaining strength, I say, can't be impugned. I mean, it's clear that Last Bus was in a strong position. They chose to come to Dawson's because their finance was cheap.
Well, yes. It's one way of describing it. They were in a strong position in that they were big enough to have gone down the direct contract with bank loan route if they wanted to.
Yes.
But that's the only sense in which the parties could be said to be of equal bargaining power. You've accepted that there's no possibility of getting either from your clients or from any other HP company, different terms.
That's correct. But I do say that the availability of bank finance is, I mean, the Malone friend challenged, you saw the judge relied on the pleading, which discussed bank finance.
Yes.
I'm not going to go back to unless you want me to.
Well, this was the point that Justice Christopher Clark made in Balmoral, isn't it? He put it equal footing for price, but for terms they were not on an equal footing.
Well, that's the situation. I mean, in this case, there could be negotiation on the price, but the terms. And I think the reality is, with most of the authorities, certainly all the HP authorities, are all standard term cases. The reality is that companies that provide HP, certainly on the evidence we have here, and almost invariably in my experience of dealing with HP companies, they have standard terms which look very much like the standard terms in this case.
Now, as it happens, this is an HP case, but both you in your submissions and the judge, in fact, at paragraph 37, little Roman 2, mentioned the possibility of buying directly.
Yes.
But what would be your submission if there was a direct contract of sale?
Well,
with the supplier?
I'd say in those.
Sorry, can I just finish the question? Would you contend that it would be perfectly reasonable to have an exclusion clause of this kind in the contract of sale? In other words, you're paying a lot of money to get a coach which you think will work and will work safely. In fact, you're getting something which is completely duff.
Well, let me give you two approaches to that. The first is, as a matter of pure contract, that is reasonable.
No, I know as a matter of pure contract. That's why Parliament enacted this Act.
But again, in terms of, outside of the Act, would it be reasonable if a party like Last Bus approached Mercedes-Benz and said, we want these coaches?
I understand the position in contract law, at common law. I do understand that. What I'm asking you is whether you would be contending, if you were standing in an appeal like this, and your client was the supplier directly in a contract of sale, would you be contending that such a clause is reasonable under ACTA?
I think I would have to take into consideration all of the other issues, because in the if you get to that position with the EvoBus clause, on my understanding of EvoBus's terms, they were offering warranties, so it's not not the same clause. So I think it's a different argument, and I don't think I can tell you what my position would be for a supplier without knowing exactly what the supplier's terms were.
That's fair enough.
It's certainly the case that EvoBus were offering warranties. Certainly.
But in a sense, forgive me, but leave aside the EvoBus, aren't the points you make about the background with EvoBus, it is the case that you stand in the position of a supplier, in the sense that you sell or hire goods to the purchaser. And if there is no contract with anybody else, you are the supplier. So what's the difference?
Well, again, I say it's certainly in the circumstances of this case, the fact that the understanding of everybody was that it wasn't the case that Last Bus came to Dawson and said, we'd like to buy some buses, please. They went to Evo. They said they visited them, they looked at the coaches, they asked questions.
It's exactly the same as Purnell.
Well, I differentiate Purnell because it's a much smaller case, and it's prior to the more recent Court of Appeal authorities as well. But in this case, it's not just the same as Purnell, because you have a direct contact. I know in Purnell the person was an agent of the company, but in this case, there's no question of agency. They went to Mr. Beagrie, who
Why does it matter whether it's an agent?
Well, I think in this case it's just very clear that they went directly to EvoBus. They spoke to a senior representative of EvoBus. He visited them. He made representations to them, and they exchanged contractual documents. And that must be relevant, surely.
Could I ask, for my part, I would quite like to understand how you identify this trend.
Well, the trend goes no further than the quotations that you were shown.
Yes.
Which start effectively with the Watford decision in 2001.
Yes.
And then going into Granville in 2003.
Yes.
And Good Life in 2018. I said, I don't want to overplay the trend. I'm not saying that it's a substantive.
It seems to be very important in the judge's reasoning.
Well, I think it is, but I think again he did no more than say. I mean, he sets out the arguments that were made to him, and then he applies it at the end. But in my submission, it goes no further than saying that when you are looking at the test for ACTA, the consideration of the nature and stature and negotiating position of the parties is obviously relevant.
Well, can we look at them just very quickly? Watford, because I'd like to know what you say about it. Watford, page 127 of the bundle, paragraph 55. I think you rely upon where experienced businessmen representing substantial companies of equal bias of negotiating agreements, etc. But given what then follows in paragraph 56, it's plain that Lord Justice Chadwick has in mind actual negotiation of the risks.
Yes.
And that's what Mr. Justice Christopher Clark identified as well in relation to this case in Balmoral. So I don't see how that really has any bearing on this type of case where there is no negotiation of the risks.
Well, to some extent there is negotiation of risk, because I've talked about pricing. The pricing relates to risk. If you go, the reality is the cheaper. If you're taking the cheapest pricing, there's obviously some sort of payoff with what else you're getting. It can't be said that as the courts we're going to assume that the cheap pricing comes with no other cost. In terms of the actual
It's a
word,
completely different order. In that case, they negotiated which should bear the risk, the cost of insurance, of making good the loss of profits and other indirect or consequential loss. That's completely different to just simply trying to get the best price you can.
And I accept that. And I don't submit that that you can take the fact of Watford and put them over this case. That's clearly not right. But when you take this case and then you take the cases that follow it, which we can go to, what I say is all it's showing is in the courts are looking at the true elements of the parties, and all the trend is nothing more or nothing less than the court's taking what I say is the common sense approach, that there is a difference between the position of somebody in the situation buying a photocopier for a couple of £1,000 or somebody buying a car for £10,000 and somebody buying coaches for £7.5 million.
Well, can we look at the next one then, Lord Justice Tuckey?
Granville.
Oh, yeah, 139, paragraph 31. He seems to have undertaken the analysis under UCTA. And this, of course, if you bear in mind, these aren't specifically a party's standard terms. They are trade terms,
Yes.
which are incorporated. Presumably they were incorporated in a consignment note or something.
Yes.
And what he says, as I understand it, is, he says, less enthusiastic about its intrusion into contracts between commercial parties of equal bargaining strength, which of course is the issue in a sense, and references that in fact most of this agreement are the type of international commercial activity which isn't within the Act.
Yes.
So again, does that really help to show a trend?
Well, I think it does, because I mean, the reason he talks about trends are twofold. I mean, one goes to the start of paragraph 31. The 1977 Act obviously plays a very important role in protecting vulnerable consumers from the effects of draconian contract terms. Now, the degree of protection required for people in those circumstances is very different to the degree of protection required by LastBus or other large commercial organisations. So to that extent, I say, yes, this is a continuation of the trend of just recognising...
But with respect to Lord Justice Tuckey, the Act intrudes into these contracts.
It does.
So what relevance is his lack of enthusiasm for it?
Well,
Maybe expressing an opinion he's not enthusiastic about it. So what?
What I say is that when he says lack of enthusiasm, that follows from fundamentals of contract law. And my learned friend took it to photo productions and Securital, where again you have discussion about underlying contractual reluctance to interfere with bargains. And obviously that's pre-UCTA. But that trend then follows its way through. And in my submission, when one looks at classic contract theory and looks at the House of Lords in photo securities, it's no surprise that a judge should be reluctant at best to interfere with the arrangements made by experienced commercial people where there's no obvious imbalance of negotiating position. So I say this is part of the trend, and it follows on. And as I said to you, I accept the facts of Watford are very different. The facts of this case are perhaps more different because in terms of subject matter and this point that only part of the contract fell within UCTA. But overall, what I say, the trend is simply showing that the courts are becoming increasingly reluctant to impose judicial views in place of the decisions made by commercial people who have done so presumably with their own judgment.
Can I put to, because that's a very important submission, if I may say so. It's only fair that you should be aware of the two concerns that I have in this context. One is that I'm not quoting verbatim what you just said, but in effect you were saying there is the fundamentals of contract theory, and you accept that that's the common law, but isn't it absolutely fundamental that statute has intervened? Isn't our first duty as judges to give effect to the will of Parliament? We can't just carry on as if nothing has changed. Whatever contract theory may have been a common law. So what's your submission about that?
Well, my submission on that is the same as earlier. I don't think anything in this judgment or in the judgment that follows it is undermining the will of Parliament. The will of Parliament is clear in UCTA. What's happening here is the courts, and in these cases the Court of Appeal, are applying the law in the way that presumably the judges in those cases believe to be consistent with the will of Parliament.
Well, I'm afraid that with respect to Lord Justice Tuckey, saying things like, I'm less enthusiastic about its intrusion, that's quite pejorative language about what Parliament has done. What a judge's views are about what Parliament has done, well, it may be one or another, but isn't our duty simply to apply what Parliament has said?
Well, as a starting point, I certainly don't make any submission that contradicts the point you make, that your duty, the duty of the panel is to apply the law in the way intended by law.
I understand that submission. I'm sorry to interrupt you, but time is limited, and I want to be fair to you. The second point is you reminded us of what Lord Wilberforce said at photo production. But actually, at page 19 of the bundle, page 843 of the speech, he made the point that Parliament has intervened. Since then, Parliament has taken a hand. It has passed ACTA. This Act applies to consumer contracts and those based on standard terms, and enables exception clauses to be applied with regard to what's just and reasonable.
Well, I think, Mr. Bendy, you said you accept, of course, as you must, that ACTA is applicable to a case of this kind. But you're saying that in what is fair and reasonable is quite fact-specific.
Yes.
We've been over that.
Yes.
And in bearing in mind what's fair and reasonable, the bargaining power, commercial experience and so on of the parties are relevant, and experienced commercial purchase directors or whatever Mr. O'Sullivan was shouldn't be treated as though they're helpless little old ladies. And that's a sort of...
In a nutshell, yes. I think there's a fine line between a situation in which one says that Lord Justice Kentucky may have exceeded the bounds of his jurisdiction, but in my submission, it's merely reflecting that point. There is a distinction. The Parliament can't have, Parliament perhaps shouldn't be taken to have intended that the degree of protection that the courts will impose in respect of the little old lady who's bought her car would be the same as Mr. O'Sullivan buying his millions of pounds worth of buses.
Yes, that's very helpful. Thank you.
Could I ask you this? What do you say about Section 3 of ACTA?
Well, I say the test is the same. It's quite clear that Section 3 doesn't say that you can't have exclusion clauses in standard terms, or that in that situation there's a different.
What about whether or not it's engaged in this case?
Well, I say it's not engaged in this case. I mean, I haven't at any point contested the fact that these are standard terms. I mean, certainly the pleading made reference to Section 6 and didn't make reference to Section 3. There was no arguments about Section 3. I am going to agree with my learned friend on this point to some extent, to say that when one looks at the authorities, I think Purnell in particular, the judges have seemed to have treated it as being a situation in which it doesn't matter. And they treat...
Well, the main one is Mr. Justice Longmore, isn't it, who basically says it doesn't matter.
I think so. I thought there was a passage. I think there's a passage in Purnell. We'll just go there. But again, the passage, I don't know, it's of any use to you. I mean, in essence, what Purnell says is what Justice Longmore said, which is that we're dealing with it doesn't matter if we're dealing with Section 3 or Section 6, the test is the same.
Well, I think what follows on from that is, as I understand it, you say that you could have, the coaches that you supplied could have been taken off the ferry and transported to last bus, and they could have gone in there, turned the ignition on. It didn't start, but each bus blew up, so they didn't get any bus at all, effectively. And you would say we have no responsibility for that.
Yes, and I say that very directly because that must follow.
Yes,
but what I say is that at the time of the agreement, we believe that they had recourse through warranties.
Can I then just ask you in relation to Section 3, does that not mean that you are within 3(2)(b) claiming either to render a contractual performance substantially different from that which was reasonably expected of him, or in respect to the whole or any part of his contractual obligation to render no performance at all? Because you were expected to supply a large number of very valuable coaches, but you are saying that you didn't actually have to provide any working coach at all.
Well, I mean, again, I'd say that requirement is subject to the test of reasonableness. And I say that our position is that we had no liability in respect of that. So if the buses had turned up in Dublin and they turned the keys and they've blown up, we would have said over to you, Evo. But so in essence, yes, we accept that we say we had no liability. And again, that clause would, under Section 3, fall into the test of reasonableness.
See that? Forgive me. That then it seems to me takes one back to the judge's judgment, where he says at 39. That there's only one factor that points away from reasonableness. They didn't have the option to contract with anybody else. Surely the really big factor here, in terms of the lack of reasonableness, is that they could be acquiring coaches from you which were absolutely worthless and paying millions of pounds for them. That's surely the factor against the reasonableness of this clause.
I accept that that's a factor. I say it's not the only factor.
But the major factor is the core of the unreasonableness argument is that it isn't reasonable to provide no recourse if you do not actually provide performance of your contract.
I accept it's a major factor, but what I say is...
The judge doesn't seem to have regarded that as even a factor. He says there's only one factor.
Well, I would accept that's a factor. I don't think the judge deals with it expressly, but what I say is it was counterbalanced significantly by the evidence of EvoBus's dealings with LastBus. Look, I'm going to move on. I'm going to deal relatively briefly with the actual points of appeal. I think we've dealt with almost all of them anyway.
Yes.
It won't take long. Firstly, as I say, I've grouped them into firstly the Purnell points, which is ground 1 and 5. Secondly, the contractual nexus points, grounds 3 and 4. Factual points, grounds 2, 6 and 7. And then finally ground 8, which I say isn't really a ground of appeal, it's more of a summary. On the Purnell point, I don't intend to take it any further. We've discussed it and heard my submissions. I won't go any further. Contractual nexus, grounds 3 and 4. As I say, as put in the grounds of appeal, I say what's being said is the judge couldn't or shouldn't have made the decision without a decision being made in relation to the actual contractual relationship between the three parties. And I say as a matter of law that's wrong on the basis that I've already said that the date of assessment is the date of entering into the contract. And what you have to look at is what was the subjective understanding as of that date. I say the most important point there is we have shown you the vehicle hire or the vehicle order agreements between Evo and LastBus, but also the pleading itself that it is LastBus's own case that there was a contract. Moving on to the factual points, I'll take them one at a time. Ground 2. Again, it's a point we've discussed. I say the judge was entitled to infer from the respondent's pleading that bank finance would have been an option. I also say, just as a matter of judicial notice, it could have been said that bank financing was an option. The evidence before the judge, and he records it in his judgment, is that the selection of Dawson's was because it was cheap, or because it was the best APR on the market.
Yes.
Ground 6 refers to paragraph 34.12 of the amended defence.
Remind us what that was.
That's dealt with by the judge, paragraph 34 of the judgment. This is the point my learned friend made about the, so if one looks at the judgment, page 77 of the main bundle. All I have to say about this is that the judge looked at this point and he did decide it's highly controversial and would need a trial to decide, but he then makes it clear that he's not considering that as part of the factors that he took into consideration when he made his decision. Ground 7, this is the judgment at paragraph 32 on page 77. This essentially goes back to the Purnell point.
Yes.
I say that the judgment statement in there was factually correct. It's right to say that it is conceivable that there may have been a situation in which liability was excluded by both parties, and that would leave Last Bus with no remedy. And I've already addressed that. That's what they agreed to. That's what they would have to deal with. But also that leads to a number of questions about the reasonableness of both clauses. And it doesn't follow that because there are exclusion clauses in both contracts, that one or both are necessarily unreasonable. And then finally, ground 8. And then I'll let you look at ground 8. It's on page 17 of the bundle. I think my pleading is described by the judge as a forensic flourish at one point. I think this is also a forensic flourish.
Yes.
I think it's no more than a summary, a very pithy summary of my learned friend's points of appeal. But I say that it's wrong to say that the decision of the judge leads to a situation where prima facie an exclusion clause in a commercial contract is valid unless reasons are shown why it's not valid. All the judgment does is it applies existing authority, which emphasises that you must take account of the nature, size and bargaining position of the parties to the contract. So, my lords, I've given those reasons. In my submission, you should look carefully at the grounds of appeal and you should consider the extent to which those grounds of appeal are reasons to impugn this judgment. In my submission, the judge has looked at the law. His examination and his presentation of the law are very much in agreement with everything that's been said in this court today, particularly as said by my learned friend. And then he's applied the facts of this case, which I say are relatively unusual facts. And he's come to a decision based on his view that many of the factors upon which he relied were either obviously correct or not in issue. And that's why this case was suitable for summary disposal. So unless I can be of any further assistance, they're my submissions.
Can I just ask one question? You've understandably focused on the precise grounds of appeal, but would you accept that, although not expressly the ground of appeal, it's effectively implicit in the overall tenor of the grounds of appeal that there is a challenge to the judge's refusal or decision to determine the question of reasonableness on a summary basis rather than sending it to trial?
Lord, no. I'd say when one looks, I've just gone through the points of appeal, and I say the grounds of appeal are very specific. They do obviously attack the conclusion, but they do so on the basis of those 7 specific points if my learned friend had wanted to plead that the judge had not acted in accordance with the authorities we're all familiar with under the summary judgment jurisdiction, then I'm sure they'd have said so.
It may be a distinction without a difference. I mean, I read the grounds of appeal as saying, for the following 8 reasons, the judge was wrong to find that there was no issue to be tried.
I think
and therefore
I'd agree,
shouldn't have given.
but it is those 8 issues
Yes.
that you need to look at, not anything else.
Yes. Right, thank you very much, Mr. Benzie. We're very grateful to you. We'll just rise for a few minutes.
Court rise is able.
Mr. Jones, we're immensely grateful to Mr. Benzie, whose coolness under fire is to be commended. In fact, if there were a medal for coolness under fire in court, he would deserve it. But nevertheless, we need not trouble you. The consequence is that in due course the appeal will be allowed. We won't have any order drawn up at this stage because if an order is drawn up, then Mr. Benzie would be in the position of having, perhaps, we're not encouraging it necessarily, to seek permission to appeal further without knowing what the reasons were against which he would be appealing. So we will simply, at this stage, reserve judgment. When the draft judgment is handed out, when the draft judgment is sent to counsel, it will, as counsel well know, but I still have to say it in every case, firstly be subject to the limitations on publication identified in the Counsel General for Wales's case. That is only the parties and their legal advisors until the formal judgment is handed down. And secondly, it's sent out not for re-argument of the case, but for correction of typos and errors of dates and so forth. We will also invite the parties to agree costs, if that's possible, and any consequential directions. There's a limit to what consequential directions could be given without some involvement on the part of the second defendants, but we'll leave it to the parties to deal with that. We can do more or less anything by consent of all parties, including the second defendant, but otherwise we may simply have to send it back for the judge in charge of the commercial court to give appropriate directions. I think that deals with everything.
I'm very grateful. At the risk of disappointing Mr. Roundtree, who's laboured long and hard to get the additional documents, I'm imagining that your lordship hasn't now got the need to see them, but if your lordships want them, they are here.
Well, if they've been compiled, could you please hand them in?
Of course, I've got three sets. They're not all clipped together, so they need to be kept separately. Lord, there is a further copy here of the amended particulars of claim. You've already got that in the bundle. It's only in case you want to see the appendices behind it, which are not in the bundle. Right. So that was the important thing. And I've also dealt with, rather Mr. Roundtree has, the cross-referencing of R&B custom brokers. So what I've also got to hand in is the Weekly's law report. And just for your note, the Weekly's reference is at page 2 of the head note, and it's page 855 of the all links. That's the cross-reference. So I got this for you as well. Thank you. And I'm so sorry. May I ask you to hand these up as well?
for the record, we have got amended particulars of claim, another version of R&B Customs Brokers, EvoBus Terms and Conditions of Sale, issue October 2007, and then a clip beginning A826 to A829.
Lord, that, without a front sheet, but that is the Dawson claim against EvoBus.
Some of it, yes.
With paragraph 9.1, I think,
Oh, I see.
setting up the battle of the forms that Mr.
Right.
Spence has told you about.
And purchase order with pending conditions of purchase. Probably enough passing gifts to be going on.
Thank you very, very much.
All rise, able.